Now calling case 19-CV-484, Colborn versus Netflix, Inc. et al. No appearances in the courtroom. Can I get appearances by phone, please, starting with counsel for the plaintiff?
Yes, George Burnett and April Barker appearing for the plaintiff.
And appearances for the defendants?
This is Lita Walker, along with Lee Levine and Matt Kelly from Ballard Spahr, appearing for defendant Netflix.
And this is Kevin Vick from Dassey, Vick, Carolyn, appearing for defendants Chrome Media, Laura Ricciardi, and Moira Demos.
And James Friedman from Godfrey and Kahn, appearing for all of the defendants.
So good morning, everyone.
Morning.
Good morning, Your Honor.
Morning.
So we're here for a status conference in this civil matter. Before we begin, I'll just summarize a little bit of the procedural background, at least as far as the court is aware or understands it to be. This is a defamation case. It was originally filed by the plaintiff against Netflix, Inc., Chrome Media, and some other defendants in Manitowoc County Circuit Court, and it relates to the Netflix series Making a Murderer. It was filed back in December 17th of 2018. On March 4th, 2019, while the case was still in state court, the plaintiff filed an amended complaint reducing the number of defendants. I think the amended complaint just named Netflix, Chrome Media, and then Laura Ricciardi and Moira Demos. And the claims were for defamation, negligence, intentional infliction of emotional distress. The defendants removed the case to federal court on April 3rd of 2019 under the court's diversity jurisdiction. Shortly thereafter, about a month thereafter, on May 9th, Netflix filed a motion to dismiss under 12b-6, contending that there was no plausible claim for defamation. On May 10th of 2019, Chrome Media LLC filed a motion to dismiss. That motion to dismiss is based on some service issues and a contention that because the complaint was not timely served under Wisconsin law within the 90-day window provided by the Wisconsin procedural statutes, the statute of limitations had expired, and so the case needed to be dismissed. There was a lot of briefing back in 2019 with respect to the various motions. There was also a motion to file a second amended complaint. On December 19th of last year, when the case was assigned to Judge Pepper, there was a hearing, I think telephonically, maybe it was in person. I guess that was before COVID, so there were still in-person hearings. And at that hearing, the court denied Netflix's motion to dismiss, granted the plaintiff's request to file a second amended complaint, and concluded that with respect to the other defendants, Chrome Media and the individual defendants, that there was a factual dispute about service of process that required an evidentiary hearing, which was then scheduled and rescheduled, and then ultimately, I think, set for today, but then when the case got reassigned to me, that was canceled. So that issue is still pending out there. The second amended complaint was filed on January 3rd of 2020. The parties have stipulated that, at least with respect to Chrome and the individual defendants, there's no need to respond until the motion to dismiss is resolved. As I said, there was an evidentiary hearing set for March 6th, and then it was reset for July 8th, and then for October 22nd by Zoom. On March 3rd, Netflix filed a second motion to dismiss the second amended complaint. I guess it's the first motion to dismiss that complaint, but it's the second motion to dismiss by Netflix in the case. That motion is now fully briefed. On September 21st, about a month ago, the case got reassigned to me, and so about a week later, we set a notice of this status conference. And then I see yesterday the plaintiffs filed a motion to compel initial disclosures. So a little bit of background here. So that's my understanding of the procedural posture generally. I'm obviously relatively new to this case, much newer than the rest of you. This is one of more than 200 cases that were reassigned to me about a month ago. And so I am trying to systematically go through these cases. I'm setting half-hour status conferences in many of them to try to get a sense of what needs to be done, basically to triage the docket and also to triage these cases. Try to figure out where I should be focusing the court's time and resources most efficiently. So that's sort of the purpose of today's call. And I've got others calls this morning, so we're a little limited in terms of time. And what I really want to do is focus on have you help me focus where I should be spending my time and attention to get this case moved forward. So I'd ask, and I'll start with plaintiff's counsel, then we'll go through counsel for Netflix, and then counsel for Chrome and the individual defendants. And I'd ask each first to, we'll go one by one, but I'd ask you first to confirm that basically my summary of the background procedural posture is correct. If it's not, let me know if I've got something wrong or if I've missed something, please do. So that's thing one. And then thing two, provide me, if you could, just briefly, from your client's perspective, where things stand and where the court's attention should be at this point to move this case forward. Now, I know that we've got basically two motions to dismiss pending. The Chrome individual defendant's motion to dismiss related to service of process, and then Netflix's motion to dismiss, which let me also say I've reviewed the briefs, and I'll say reviewed, not read, because they're voluminous, and I certainly haven't read all the underlying cases, but I have a general idea of what the issues are. So with that in I guess as context, where do we go from here with respect to the Chrome motion to dismiss? I understand that there's an issue about service of process and whether service was completed by March 18th, 2019, which is the 90-day deadline under Wisconsin law for the case to have been commenced in order to save it from the statute of limitations. And I know that I listened to the hearing transcript from the last hearing in front of Judge Pepper, and I know that she thought there were factual issues there. But with respect to the plaintiff and the Chrome defendants, I'd ask you to hone in on what exactly the factual disputes are, and I wonder whether are the facts actually disputed, or is it the facts aren't disputed, but the characterization of those facts or the significance of those facts is disputed. And so, if we're going to do we need to have an evidentiary hearing or not? Could we replace that with a set of stipulated facts as to what actually happened? Did the process server go on X date or not? If we can get all those things done, can the court just rule without an evidentiary hearing? If that's not the case, tell me that. So that's on that piece of it. With respect to the Netflix motion to dismiss, it looks like there's a lot of factual matter that was added to the record, and it looks almost like a motion for summary judgment to me. Again, I haven't gone through all the briefing and all of the supporting materials, but there's a whole lot of factual sites there and a lot of factual material. And I'm wondering how best to deal with that. Is this just basic? I mean, I ordinarily don't like to have, I don't think it's appropriate to have two bites at summary judgment. So if this is a fight over what the undisputed facts show, I wonder whether we ought not save that motion for post-discovery. But anyway, that's an initial thought. I'm happy to hear views otherwise. And then this latest discovery motion we can deal with too. So with that very long predicate, and I apologize for running on, Mr. Burnett, tell me whether my procedural summary was accurate or needs to be updated, and then address each of the motion to dismiss.
The
Motions to
summary
dismiss. Go ahead.
The summary is accurate, Your Honor. I would add only that there are allegations in the second amended complaint about making a murderer two that may influence as to whether or not the Chrome Media defendants should be removed from the case. April Barker was going to address most of the other things. I can go ahead and do it unless the court wants to hear from April, who's smarter than I am.
Mr. Burnett, I'm sure you're smart enough to do it, but if Ms. Barker is prepared to do that, that's fine.
Thank you, Your Honor. Attorney Burnett is too kind. I assure you, I'm not smarter than he is. But in any case, I just would add a couple of things. I agree completely that with Attorney Burnett that his summary was accurate. With respect to the motion or the evidentiary hearing on service of process, I believe there are at least a couple of issues that are factual in nature. One is the question of reasonable diligence, I think, on the individual defendants. The parties had talked about trying to craft a set of stipulated facts, but I think that the defendant's preference, as I recall, was instead to try to set this after the other motion, and the sort of attempt to craft a stipulation sort of died on the vine at that point. But we're happy to revisit that to see if we can come up with stipulated facts on which a reasonable diligence determination may be made. Otherwise, there might be a need for some very limited jurisdictional discovery, and we had been in discussions about that when, again, things essentially got put on hold. With respect to the other issue is with respect to Chrome Media, I believe that there are factual issues about the scope of agency of the registered agent under California law, and exactly how much authority he was provided, and regarding the offices, where are the offices of Mr. Bernari and or Chrome Media. So those are issues that we do think need to be fleshed out at an evidentiary hearing at some point. I think that those issues could be, if the parties all put their heads together and worked on trying to stipulate what they can and discover the rest, probably within 3 to 4 months we could be in a position to have that hearing. With respect to, and that's independently of what happens with the substantive motion to dismiss that's pending as asserted by Netflix, the court has identified the plaintiff's concern with that motion, which is that there's a great volume of evidentiary material that was put before the court. With that motion, it's not a conventional motion to dismiss by any means. And the issue in and of itself of whether the defendant's broadcast was a substantially true portrayal of the material available depends on that material, which unfortunately the plaintiffs have not had complete access to. I would add to the court's summary, outside of the court record, discovery requests were served with the initial pleadings. Those have not been answered to date. Ultimately, a Rule 26F conference was held at Judge Pepper's order in May of this year, and a Rule 26F report was submitted. In that report, the parties have respectively outlined their positions regarding discovery, but in a nutshell, it's plaintiff's position that discovery, especially regarding the raw footage and the material that was available to the defendants at the time of the broadcast, is germane to the issues presented in the motion with respect to whether there is a substantially true argument as asserted by the defendants, or a defense based on the substantial truth defense. I would also just note that the second amended complaint, as I think Attorney Burnett may have noted, raises issues relating to making a murderer two, which would be beyond the scope of any alleged statute of limitations defense, and therefore it's plaintiff's position that all of the defendants would have claims going forward against them regardless of the outcome of the service of process motion filed by Chrome and the individual defendants. From the plaintiff's perspective, the next steps are to, hopefully move forward with the initial disclosures. That's our goal in filing the motion to compel, potentially address other discovery, particularly that's related to the pending motions, and move forward with the case as appropriate based on that discovery and how it may bear on the motions that are pending.
Thank you. Let's see. Ms. Walker.
Your Honor, this is Rita Walker on behalf of Netflix. So you asked us to address two questions, and the first one, yes, I'll confirm that your recitation of the procedural history is absolutely correct, and the only additional thing I would draw your attention to is that Joint Rule 26F report filed on June 1st of 2020. It's at docket number 141. Your second question, and that sets forth the parties' differing views in some detail on discovery, so I won't rehash that at length here. Your second question is, what's the most efficient way to deal with this case when you suddenly inherited 200 new cases? And the short answer to that, Your Honor, is to decide Netflix's pending motion. Netflix brought that motion, on its own behalf. It's not a motion brought by all defendants, but the arguments, if you agree with them and if you grant the motion, will dispose of the entire case. And that is the simplest, most expedient thing to do right now, is to reset the hearing on that motion. And if you were to grant it, you would avoid fights over discovery and what I'm hearing is a 3 to 4 month process just to tee up an evidentiary hearing. And of course, until that evidentiary hearing occurs and you rule on the also pending 12B5, we're all in a bit of limbo as to whether 3 of the 4 defendants are even parties to this case, and if they're not, what that would mean in terms of conducting discovery without them when they're not subject to the discovery process. So things get really complicated really fast if we move into discovery or into an evidentiary hearing, which I know Mr. Vick will talk more about. I do want to address your concern about the volume of the materials that we filed on March 3rd. Despite what Ms. Barker said, it is in fact a very conventional motion to dismiss, and I would encourage Your Honor not to assume it's structured as a summary judgment motion just because there's a lot of stuff. This case is about a 10-hour documentary spread over 10 episodes, and that documentary was about not 1, but 2 trials, to say nothing of Mr. Avery's life. It's about his erroneous conviction for a rape, his appeal of that and his eventual exoneration, and then it's about the trial for the murder of Teresa Halbach, and frankly, his appeal of that. And so the material you see in the record on that motion is a whole lot of video of the episodes themselves, which Your Honor is going to have to take a look at to decide the motion, and then things that are judicially noticeable, including a lot of trial transcripts and deposition transcripts.
But the volume, I don't want to distract in terms of just the volume. That's not it. It's you've gone beyond the record in the pleadings, which takes you out of 12B6 and puts you in summary judgment. In terms of summary judgment, because and when I start considering things outside the pleadings, then it's a rule. Then I can treat it as a motion for summary judgment. And if you want me to do that, I will do that. Now the plaintiff may say under what is it, Rule 56F, we need more, or is it D? I need more time to take discovery to deal with those factual assertions. That may or may not. They may say that. I don't know if they've said that or not. But I can deal with that, and maybe they don't need discovery to respond to your arguments. What I guess my instinct is, if you want me to go ahead and rule on that motion now, I can do that. But if I do that now, you don't get a second bite at summary judgment. If you lose, if you win, you win, right? But if you lose, and we take discovery, I'm not inclined to give a defendant a second opportunity at summary judgment, making the same arguments that they insisted that the court decide right out of the box. Does that make sense?
Yeah. I guess I would disagree with one thing Your Honor is saying. You'll see citations in our brief that everything we have put in the record is properly considered at the motion to dismiss stage, either because, and there's lots of case law on what the court can consider at Rule 12, it's either embraced by the pleadings, such as the episodes themselves, which are at the heart of this case, or it is judicially noticeable. And so, we want our shot at a Rule 12 motion. We think we're entitled to it. There's a new operative pleading. This is our first motion to dismiss on the new operative pleading, and we brought it under Rule 12. And we certainly do not believe it is a summary judgment motion, and we think you ought to decide it under the Rule 12. You'll see in the briefing, excuse me, Your Honor.
No, go ahead.
Yeah, you'll see in the briefing the plaintiffs in their opposition talk about the need for discovery. We've responded to that. I don't need to get into that here. And, of course, we'll be filing a response to the motion they filed yesterday asking for initial disclosures. But that's been briefed, and it's right, and you can decide it. And everything that is in that motion is properly before the court at the Rule 12 stage. And of course, if you disagree that there's something you shouldn't consider at the Rule 12 stage, you can say that. You can say, they put this in evidence. I don't think it's properly considered. I'm not going to consider it. And then based on everything else that's before me, here's my decision. Your Honor, I think that's basically it. We think that if you don't decide that motion now, then what we face is 3 to 4 months for the parties to figure out whether the producer defendants are properly in this case. Conducting discovery during that point is going to be completely inefficient because we don't know who the defendants are. And to get back to your question, the efficient way, the way to manage court resources on this is to take a look at the motion under 12b6 and decide if this case can get past that plausibility standard.
Thank you. Mr. Vick.
Good morning, Your Honor. So one thing, I did want to correct one thing in your recitation of the case. I believe there may be a misunderstanding. The October 22nd hearing that was taken off calendar last month after the case was reassigned to Your Honor was actually on Netflix's motion to dismiss. There was no pending hearing date for the evidentiary hearing with regard to my client's motion to dismiss under Rule 12b5.
Okay, thank you.
Yeah, sure. Now, in terms of your second question, how do we tackle this? How do we move it forward? I agree with Ms. Walker conceptually, analytically, with a view towards judicial efficiency in terms of saving both the parties' resources and really also the court's resources to a potentially large degree. It makes sense first for the court to rule on Netflix's motion to dismiss. As Ms. Walker stated, and as plaintiffs have conceded in previous filings in this case, if Netflix's motion to dismiss were granted, those same arguments would also be available to the producer defendants if they ever had to respond to the Second Amendment complaint, the result of which is that if Netflix's motion to dismiss were granted, it would dispose of the entire case. So that one could obviate the need for all sorts of other conduct in this case, all sorts of other both court and party activities, including the evidentiary hearing and what would need to go into it. For that reason, we would strongly urge that Netflix's motion to dismiss is the fulcrum. That's where it makes sense to start, and then for the decision tree to flow outward after there. In terms of the evidentiary hearing, I'll be candid. It's not entirely clear from Judge Pepper's thoughts at the hearing precisely what the disputed facts were. There's sort of intimations of what they might be. I do think in the first instance that myself and plaintiff's counsel could try to work out and see to the extent to which we can stipulate as to facts that might then be able to replace an evidentiary hearing. I don't know if we'd be able to get all the way, but we might. So that is something that may make sense. But I do think in terms of when to hold it and what it should be shaped with, it would make sense for Netflix's motion to go first. And also, it might make sense, something that occurred last night was that Your Honor may have thoughts after reading through the parties' papers with regard to the producer-defendant's motion to dismiss for insufficient service, may have thoughts about if there's specific areas of fact where there's a dispute where Your Honor would welcome additional evidence. And I know that we would be welcome to any sort of guidance or input on that regard from Your Honor. But regardless, we're happy to try and work with plaintiff's counsel on some sort of stipulation of facts to see how far we can move the ball forward and possibly all the way.
So thank you.
And I would add one last point, which is with regards to discovery, we share Ms. Walker's view. There's Rule 12 motions pending. Those should be resolved before discovery moves forward. That discovery may prove to be unnecessary, and especially with regard to my clients, it's not even clear whether they're proper parties to this action. So there's a cart before the horse problem with discovery. And even if it were the case that discovery were to proceed just against Netflix in the first instance, that could be woefully inefficient. We could have duplicative discovery. We could have the problem of, do my clients need to be spending time and money on my taking part in the discovery process that in a case in which they may or may not be proper parties. So in order to have, one track, avoid duplication, avoid the inefficiency, again, it would make sense to hold off on the discovery. As for the pending motion that plaintiffs filed yesterday, obviously, we oppose that, and we'll make clear all of our reasons more when we file our opposition at the due time pursuant to local rules.
Yeah, you don't need to address that today.
Thank you, Your Honor.
Your Honor,
go ahead.
Your Honor, this is Lita Walker. I just wanted to say two more things. First, Ms. Barker suggested that discovery requests have been pending, and I just wanted the court to understand that the plaintiff served discovery requests when he served the first amended complaint on Netflix back in March 2019 when the case was still in state court. And as you mentioned, Netflix removed, at which point the federal rules kicked in, at which point that discovery served as a complaint became null and void because there'd been no Rule 26 conference, which is what kickstarts the discovery process in federal court. So that was one thing I just wanted to clear up. And then I don't know that I mentioned that all of the exhibits filed with the motion to dismiss on March 3rd of 2020, the plaintiffs have full access to all of that. That's all judicial records, transcripts, what have you, and there's nothing that Netflix relied on in bringing that motion that the plaintiff does not also have, and I just wanted to make sure you understood that.
Oh, thank you. I appreciate that. So here's what I think I'm going to do. I'm obviously not going to rule on that discovery motion today. I'll let the defendants respond to that. But what I'm going to do is I'm going to continue this. I'm going to set another status hearing for about 60 days out, which will give me time to delve into the briefing in a little more detail. And it may be that at that time it'll give me time to be more smart substantively on the law and on the arguments that are pending. In the interim, what I'm gonna ask the parties with respect to the Chrome motion to dismiss on service. I'm going to ask that the parties get together and within 30 days file a set of agreed upon facts. If there are facts, and so do that. And if there are facts that are disputed, if you could identify those in that filing as well. If I give you 30 days to do that, is that enough time?
Yes, it is.
Yes, Your Honor.
Okay. So do that within, so that will be, let's see, 30 days is November 21st, which is a Saturday. I won't make you file something on Saturday. But how about the November 23rd? If you could get me something, an agreed upon set of facts related to service of process, also identifying any specific facts that are disputed. And again, if the issue is, reasonable diligence, I guess, because it's reasonable, that's a factual issue, but it seems to me that's a matter of characterizing or a conclusion, a determination that's made based on the underlying facts. So to the extent you can agree upon the actual specific actions that underlie that determination, that would be helpful to me. And then let's let's have a get together for another status conference on how about December 17th at 10 a.m. Does that work for everyone?
Yes, Your Honor.
Yes, Your Honor.
That's fine.
Yes, Your Honor. April Barker for co-counsel for plaintiff, that works here as well.
All right, and we'll do that by telephone as well. So you can file your response to the discovery motion. I may or may not rule on it before that time. I'll probably issue some sort of ruling on that before that time. But I would really like to have that set of facts stipulated to, and then we can talk some more on December 17th. And it may be that by that time I'll be able to resolve some of these motions, maybe both. But let's plan to talk again on December 17th. Thank you all for your contributions today, and we'll talk again in about 60 days.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.